much as we can. I'm going to be super brief. I teach here at Stanford. I teach employment law, enough said. I'm moderating this panel. We have 3 fantastic speakers, and possible 4, who may or may not come to Boston, and we'll see. And want to spend most of the time hearing from them. So welcome. We'll be talking about advocating for LGBTQ workplace equality. And I'll just very briefly give each of our panelists a chance to describe themselves and their background. So first, Ilona, legal director of the Transgender Law Center. Please introduce yourself.
Oh, thank you. I currently work at the Transgender Law Center. I've been there since January 2012. Before that, I was a staff attorney at the National Center for Lesbian Rights. And before that, I worked at a union-side labor law firm in New York City. I have sort of specialized in employment issues to a large extent, both LGBT and especially transgender employment issues. I wrote an article while I was in law school about Title VII and use of the sex stereotyping theory to protect transgender plaintiffs, and I've done other writing and litigating about this since then. And I'll talk more about our specific work in this area when I have more substance.
Thank you. Jacob Richards, Associate Attorney at Lewis Feinberg. Actually, longer. Technically, Lewis Feinberg, Lee, Renaker, and Jackson. Yes, right?
Yes.
More importantly, it's a leading plaintiff-side employment firm based in Oakland.
Yes, so I've been with Lewis Feinberg for about a year now, and we are a plaintiff-side firm that does primarily employment work. We do a lot of work around ERISA, which, how many of you know what ERISA is? Have people heard of it? It's the federal statute that governs employee benefit plans. And I'll talk about it a little bit more. We do a lot of employment discrimination work, a fair bit of wage and hour work, and also some disability rights work. Often outside of the workplace, we do sort of public accommodations accessibility work. And my path after law school was I clerked with an administrative law judge in the Department of Labor for 2 years, and then I did a district court clerkship for a year before ending up at Lewis Feinberg. And in law school, actually, looked at the National Center for Lesbian Rights when Ilona and Lisa both worked there. So we crossed paths there. And yeah, that's...
And we all also went to school at Berkeley at more or less overlapping. We've all worked at NCLR and anybody else?
Yeah, we go way back at this point.
Lisa Cisneros, LGBT Program Director at Helpline for legal assistance.
Sure. Well, first of all, thanks everybody for coming on a Saturday. It's so pretty outside, and but I think the conference overall looks fantastic, and so thanks for coming to our panel. I'll just explain my bio a little bit backwards in terms of what I did right after law school. California Rural Legal Assistance posted an announcement for a fellowship that I received. I was sitting in the CLR office, our law review office, and they posted this announcement that they wanted to start a program that was specifically dedicated to advocating on behalf of low-income lesbian, gay, bisexual, and transgender people in rural California. And they posted that they wanted to run this program out of Salinas, and they were looking for a fellow who was bilingual, a law fellow, and so Salinas is where I grew up, and actually a few years before I told my eventual wife, I was like, oh, wouldn't it be awesome if I could be an LGBT civil rights lawyer, which is kind of what I wanted to, what I was eyeing for, and wouldn't it be really awesome if I could do it at home in Salinas? There's definitely queer people there, and just lots of things happen that are wrong, but nobody's nearby to help out, and there's only so many LGBT organizations, and naturally many of them have a national focus, and they're focused on basic things like changing the formal law as we know it. And so anyhow, sure enough, this opportunity landed in my lap, you know, because my family situation, I think there was some reluctance to like pick up and move from San Francisco down to Salinas, which is, you know, smaller ag city. But anyhow, I ended up doing it and got a fellowship for 1 year, which was the for second year, and then it became a permanent program, and altogether spent 3 years running it. Then after that, I transitioned to did a clerkship for 2 years, and then went to work at a plaintiff side law firm, Leaf Cabraser, Hyman and Bernstein in San Francisco. So I did that for 2 years, and then this job opened up again, and I just couldn't resist the opportunity to circle back home and pick it up again.
Thanks. So I think we're going to do now, spend about 10 minutes and give each panelist an opportunity to describe sort of the legal background for the work that they do and particular needs of the populations they serve. Have a brief Q&A internal, and then open it to the rest of you. So, can I start off?
Yes. So I was nominated to do a little bit of an overview of the state of the law for employment discrimination protections for LGBT people here in California and nationally. Currently 18 in terms of state laws. 18 states plus the District of Columbia and Puerto Rico this year. Have laws that prohibit both sexual orientation and gender identity discrimination. And then another 5 prohibit just sexual orientation discrimination alone. I'll leave you with that exciting fact, and then maybe should I just keep
Why
going?
don't you finish up, and then we'll pause for a moment.
Nothing's happening here. Okay. Okay, so state-specific laws. California is one of those that has both sexual orientation and gender identity specific laws. We had a law in place prohibiting sexual orientation discrimination going back to the early 90s, gender identity discrimination in the early 2000s. And on a federal level, various versions of non-discrimination bills to prohibit sexual orientation discrimination, and then just in the last few years, adding gender identity discrimination to that, have been proposed going back to the early 1970s, never passed Congress. They've passed one house or another a couple of times in the last few years, but never both. Just in the last few months, a lot of the major LGBT organizations actually withdrew their support from the most recent version of the Employment Non-Discrimination Act, and because we felt that the religious exemption in it was just too broad. So it still exists, but it's kind of not going anywhere anytime soon. And there's going to be a new Congress starting this January, and a number of us are working on drafting a new bill that will actually be broader than just employment, cover housing and perhaps education, public accommodations. There's a lot of possibilities we're deep in drafting right now, so that's fun part of my job. I'm going to talk a little bit about spend most of my time talking about the evolving legal landscape of protections that are not these specific statutes, but under the existing non-discrimination laws, federal law, Title VII, that prohibits discrimination on the job based on race, color, religion, and sex. And for, again, going back to the 70s, LGBT people have been trying to bring claims for sex discrimination when they face discrimination at work because of their sexual orientation or gender identity. And from the 70s through the 90s, courts pretty much unanimously rejected these. Largely pointing to the lack of success in Congress, the attempt and failure to pass sexual orientation specific employment protections. But that situation started to change pretty dramatically with the 1989 U.S. Supreme Court decision of Price-Waterhouse versus Hopkins. That's a huge one in our field. That was the case where where a female accountant was denied a promotion. She was told basically that she was insufficiently feminine for the job. She was viewed as too aggressive and masculine. She was told she needed to wear makeup and go to charming school if she wanted to be considered for this promotion. And the court didn't have a lot of trouble concluding that this was sex discrimination because, you know, a man would not be told that he needed to go to charm school or wear makeup. Applying that, what we call the sex stereotyping theory, that it is a form of sex discrimination to penalize an employee for failure to live up to somebody else's idea of gender stereotypes, of what a man ought to be or what a woman ought to be. In the years since the Price-Waterhouse decision, it took the courts, the rest of the other lower federal courts, you know, maybe about 10 years after the Price-Waterhouse decision to really see how this changed things. For LGBT plaintiffs and particularly transgender plaintiffs. But they started turning around around 2000, and since then we've seen it's been virtually unanimous that federal courts have held that discrimination against a transgender employee because of their transgender status or their transition is cognizable as a form of sex discrimination. In the earlier cases, we're really tying it very closely to this sex stereotyping theory articulated by Price-Waterhouse, because they were cases that typically involved an employee starting to transition on the job, and so you could point to ways in which the employer was clearly, you know, engaging in, you know, say like wearing clothes or their appearance was changing in ways that, you know, really obviously in a physical way contravened sex stereotypes. You know, say an employee viewed as male who was starting to dress more femininely. But in more recent cases, including one that my organization and also more recently Jacob's organization firm represented the plaintiff in at the EEOC, Macy versus Holder, recognized that just as a per se blanket rule, it is sex discrimination to discriminate against an employee because of their transgender status. And that has been a really important move. And we have even seen in the last year or so some significant movement applying that same theory to LGBT employees who are discriminated against because of their sexual orientation alone, not because they, you know, violate somebody else's ideas of, you know, appearance-based stereotypes or that kind of thing. There are lots of interesting ways and challenges lots of interesting challenges that we are facing now, the sort of next cutting edge after we've established this rule in the law that it is discriminatory, you know, that it is illegal to discriminate against somebody in, say, hiring or firing them just because they're transgender. The next stage of things that we're working on is applying that to specific situations that come up for transgender employees, including access to restrooms, dress codes, being called by the wrong name or pronoun. These are things that might not seem obvious to a non-transgender person, but can be really damaging, stigmatizing, hurtful, isolating to transgender employees. And I'm happy to talk to you more about it afterwards.
So all of our panelists, by the way, are happy to speak with you one-on-one. Their bios, I think, are in the conference program. So if you want to reach out to them online. Okay, great. So I think what I'd like to do, actually, is have Jacob talk next, and then Ming at the end, maybe you can do a combo, quick introduction, and then talk about the work that you do. So, Jacob?
Sure. And Ilona actually left me a very good spot to kind of pick up what I wanted to talk about, which is another issue that specifically affects transgender people and sort of the next generation of thinking about what employment discrimination against transgender people looks like, which is access to transition-related healthcare through employer-sponsored health plans. So as the ERSA lawyer on the panel, I'm going to talk about a benefits issue. Access to transition-related health care for transgender people, so whether that's hormone treatment, surgeries, or other treatments that allow them to present in the world and be perceived as the gender that they identify as, impacts employment settings in a couple of different ways. Actually, before we even get to the question of kind of discrimination and employment benefits, the issue of access to transition-related care, I think, has implications for transgender people more generally being able to access employment, because with the rampant discrimination against transgender people and stereotypes in our society currently, transgender people who are able to access care and are more likely to be able to pass as non-transgender are much less likely to face employment discrimination. So when you're coming into an interview as somebody who visibly blurs gender expectations that your interviewer might have, you're going to have a much harder time. Unemployment rates in transgender communities are very, very high, in significant part due to this issue. The discrimination is so widespread, and within the wider transgender community, access to transition-related care is pretty spotty. It's getting better, and I'll talk a little bit about ways in which it's getting better, but it's often very hard to access care. I think there's also a question of whether all transgender people want to access care and want to be able to pass as non-transgender, and folks who aren't interested in that, I think, have a higher risk of facing discrimination because they're presenting in a way that it makes people who have very, negative ideas about transgender people or rigid ideas about gender roles uncomfortable. So there's in general a lot of employment discrimination against transgender people is a big problem. Once, even setting aside that, once somebody's in the door, once they're an employee, one issue that has been getting a lot of attention recently and thankfully has had a lot of really positive directions in the past few years that I think 5 or 10 years ago I would not have predicted. We've made as much progress on as we have, is access to transition-related care through health insurance policy. So up until 10, up until fairly recently, almost all insurance policies, whether it's through an employer or something you bought on your own, had an exclusion clause saying we will not pay for any medical care related to gender transition. And that's even if, so if you have, a non-transgender woman who needs a prescription for estrogen and a transgender woman who needs a prescription for estrogen, the non-trans woman gets it covered and the trans woman doesn't. So even when you're talking about types of care that have a very clear analog, that non-transgender people are getting this care, non-transgender people are getting hysterectomies paid for, transgender people aren't. So you have, for many years and in many places still, that was just a standard, that you have this discriminatory exclusion clause saying transgender people don't get access to this care, so we won't pay for it. In the past very few years, we've had a number of states come out with good state-level guidance on this issue. Basically, so California, I believe, was the first, and California passed the Insurance Gender Non-Discrimination Act half a dozen years ago, thank you. It took a couple of years for the State Department of Insurance and the State Department of Managed Healthcare to issue the guidance actually saying that, the fact that insurance companies can't discriminate on the basis of gender identity, yes, really actually means that you can't exclude care just because it's transition related. But that guidance has been out there now for a couple of years, and now there are 8 to 9 states who have similar guidance saying that it is discriminatory and illegal to deny care that would otherwise be covered simply because it's for a transgender person who's going through a gender transition. And plus, DC also has similar guidance. So that's something where there's been a lot of really interesting developments on the state level in recent years. There's also in the Title VII universe that Ilona has been talking about, there are a number of cases kind of working their way through the EEOC and through that process now, making the same argument under Title VII, because it's fairly well established by now that transgender people can bring cognizable sex discrimination claims under Title VII. And so there are a number of cases. My firm has one, Ilona's organization has a couple, pending before the EEOC saying this, when an employer provides its employees with a health insurance plan that has an exclusion clause saying we will not cover health care if it's related to gender transition, it is a form of sex discrimination. And it is something that is illegal under Title VII because you're treating, you have two employees, one who's transgender, one who's not, who are seeking the same care, whether it's hormones or other types of procedures. And most transition-related care has actually, has an analog that a non-transgender person would get under some circumstances that would be covered. And you're treating those two employees differently, And in both cases, you have somebody who has a doctor who said this is medically necessary. In terms of the guidance from the medical community is fairly unanimous that transition-related care is something that's now considered medically necessary by the American Medical Association, by professional associations that specialize in care for transgender people, the American Psychological Association, the Association of Gynecologists, and basically all of the major medical associations are unanimous that this is, it's not elective care. It's something that it's not cosmetic, it's not experimental, all of which are grounds that insurance companies will often use to deny certain types of care if they're experimental or not medically necessary, et cetera. So the medical opinion is quite unanimous. This is necessary care. There's still a lot of work left to do, but there's been a lot of interesting movement on this, and I'm excited to see how it continues to develop. So.
Thank you. Lisa.
What do we want to have named?
We're gonna wait. We're gonna have to do.
Oh, okay. That's not sure. Well, to piggyback on the discussion of the development of the law, and especially Title VII protections and California statutory law. The genesis of the program with CRLA was the attorneys there, before I even really came on board, realized that California had really advanced protections for LGBT people and had so for a number of years, but the organization itself had never really done the internal professional development and training so that the attorneys and the advocates could really understand the law. And CRLA on a given year helps about 30,000 people or more, and so and has a staff of gosh, I think maybe around 50 or 40 attorneys. So it's a fairly large organization. I mean, in terms of being a nonprofit and the kind of impact that they can have. So the attorneys really, this came to a head because I would say around 2006, a few cases had been litigated that involved really serious workplace harassment. I mean, actually outright violence. So there was a gay man in Salinas who was working in the field, and he relied on his foreman to get a ride to the field, out to the fields, and on repeated occasions had actually been attacked. He was beaten at one point, just punched a few times in the trunk of the car during a trip out, and then another time during a lunch break, the foreman decided, was picking on this particular man and just invited some men on the crew to throw him into a ditch, and he would give him a six-pack of beer in return for that. So he was thrown in a ditch. And so basically he went to CRLA. It's not that CRLA at that point had done any outreach on the topic or had spoken in any kind of community presentations. I mean, there's radio presentations, or there are interviews on the radio that attorneys will regularly do in Spanish language radio but nobody had ever done anything like that. But this man still somehow, I guess, was so desperate for help that he had gone to the office in Salinas and had the courage to explain what he was going through, including coming out. And it's not necessarily a place at any point that had rainbow flags or brochures that said LGBT or this, what have you. The organization did, however, have a reputation for defending women farm workers experiencing sexual harassment. And so they've been doing that for a number of years, but this was an angle that they had never really looked at. There was another client also around that time who was a transgender woman and who worked in an asparagus packing shed. And she had actually been working at the shed for a long time, and she was a poor woman, and she had never had any problems. She had actually risen through the ranks and was managing a lot of workers, and was pretty successful. But then she transitioned, and at that point, she started experiencing a whole lot more harassment. In fact, she did happen to have a boyfriend who also worked at the company, and he tried to defend her, and then there was actually a physical fight that broke out. So anyhow, once these cases came in, this organization said, okay, well, look, this must be the tip of the iceberg, because we've never even done any community outreach on this topic, and so that's what prompted them to sort of think about, how would we really develop a program that would be organization-wide across the 21 offices from the border in El Centro all the way up to north of Sacramento. So all of this is to say is that the program really started with an employment focus. It's grown since then. We do much more safe schools and education work, thanks in part to amazing contribution that Natalia has made as a law clerk. But especially early on, it was very employment focused and specifically around harassment. And I think, just having between being a law clerk and seeing employment cases and practicing employment law for a number of years now, I mean, these are so egregious that usually people think of, oh, somebody's complaining about an employment discrimination problem, it's like very minor, why is it such a big deal? But there's no question that these are violations. Now, I think it doesn't really matter if we have statutory protections, if we've got, even maybe some good case law. If there aren't enough attorneys who are available either through the private bar, through nonprofit, or through federal agencies or state agencies like the Equal Employment Opportunity Commission, if there aren't enough litigators or enough advocates to basically create a culture of compliance. And I think that's kind of the story of the LGBT program, is trying to find a way to rectify, correct some of the wrongdoings, or bring some justice to some really terrible experiences that people are having, but also to kind of create a shift in the culture where in rural communities oftentimes there's a feeling like anything goes, or we don't need to behave in the way like San Francisco, or the expectations are a little bit different. But I think gender nonconforming people are definitely the easiest targets, and especially in field work where the work is even gendered. So if you're working in the lettuce field, men have a cutter position where they cut the lettuce, and then they have a female partner who's up on the truck and packaging it. So for somebody who is gender nonconforming or transgender, the experience of behaving in a gendered way isn't really announced just when you go to the bathroom. It's announced from the get-go of what your position is, and a way of being harassed is actually being put in being a trans woman and being forced to cut. So that's been one type of way that my clients have experienced harassment as well. But anyways, take care of each other.
So maybe you could initially give us a couple-minute intro and then just segue right into the work.
Yeah, well, thanks for letting me remain a little bit mysterious, actually.
Supervising Helpline attorney at the National Center for Lesbian Rights.
Yes. So I've been at the National Center for Lesbian Rights for coming up on 7 years now, which is kind of amazing, I know. It still feels like I just graduated law school last year. But I think part of the joy of working at NCLR is that because we're doing this impact litigation, you're constantly learning new stuff, new law. We're always trying to push at the cutting edge of each of the legal issues that we work on. Did you want me to talk about NCLR generally as well? Okay. So we started in 1977, and we were founded by I think a graduate of Hastings, yeah, which is where I graduated from as well. And when NCLR started, it was a project of equal rights advocates, and its main mission was to advocate for mostly, I think, lesbian and gay parents who were losing custody of their kids because they were coming out after they were separating from the other parent. We've expanded our work to include, a broad range of issues from across the and serving the entire LGBT community. But one of the things that I especially love about the way NCLR has structured our work is we have these projects that we do, and Proyecto Poderoso is one of those projects, but we also have a youth project, an elder law project, a sports project, and what's called the Family Protection Project, which is similar to Proyecto in that the goal of that project was we were noticing that, of course, since the 70s, family law for LGBT people has come a long way in theory, but low-income families and families of color were having difficulty accessing those protections. So the Family Protection Project was created to really, one of its main strategies and goals was to bring family law practitioners up to speed on those protections that are available to LGBT families, because a lot of times if you got a lawyer who doesn't know and they don't advance certain arguments, you kind of lose the rights that you actually could have exercised. So, and I think that's a good segue into my focus on this panel, which is to sort of broaden the discussion. And when I got asked to be on this panel, I was thinking about, what is sort of the overall goal for us as far as thinking about LGBT people in the workplace. And my thought was, maybe the question is, is there a way that the law can be used to make sure that every LGBT person can find meaningful work and work with dignity at the jobs? And whether it's a recognized job or not, that's the other thing I was thinking as well. And I run our helpline, and one of the things that I am often struck by about the people who call us and the people in our community is that we're very resourceful and creative in the face of often kind of overwhelming, oppressive forces that are kind of attacking us, from many directions. And one of the ways that I think this creativity and resourcefulness comes out is that, and perhaps also a way that we care for each other, is that a lot of LGBT people are engaged in work that is either unrecognized work or part of an underground economy like sex work or drugs, or are working not in an economy that's underground, but are in the country without documentation, so without even technically the legal right to work in this country, but are doing work in economies that are sort of above ground, but where their individual contribution has to be somewhat underground. And I think when you're working, and so when I talk about unacknowledged work, I'm talking about caregiving work, for example. A disproportionate number of people providing care to their parents are LGBT, whether it's because, and we actually, and this has come up, this was something we realized in our elder law project, actually. We're still not entirely sure why, whether it's because the lesbian, gay, bisexual, or transgender child is not expected to have a family of their own, and so they're the one who's expected to care for the parent, or, well, that's one, kind of suggested explanation. That's the best one I got. But there may be other reasons as well, but certainly we're disproportionately engaged in that, and that's kind of an undervalued job. Caring for children is another undervalued job. I don't think LGBT people are disproportionately engaged in that kind of work, but it's, so I just wanted to kind of broaden the idea of what work means and how the law can recognize forms of work that are unrecognized or bring into legitimacy forms of work that are delegitimized, like sex work, selling drugs. I know it's a harder one to think that, oh, maybe the law should be into that. But maybe we shouldn't be so punitive about people who are engaging in that work to survive. Most of the times when people are selling drugs, in my opinion, it seems that they're doing so to survive, and it's something they figured out that they can do, especially if they're being denied access to the formal economy. And then I also always think of a colleague of mine, Alex Lee, who founded or was one of the founders of the Transgender, Gender Variant Intersex Justice Project, which is an abolitionist, prison abolitionist organization that works to organize with a lot of incarcerated and formerly incarcerated transgender women, especially. And he once wrote an essay which really kind of stuck with me in this collection by Critical Resistance that, when you think about what it means to do prison abolition work, a lot of work that people who are working for social justice do is prison abolition work, because the goal of prison abolition is not just to literally get rid of all prisons now, but to create the social conditions where we will no longer need prisons. And part of that means making sure that people who have jobs are not discriminated and forced out of their jobs. And I think that, so employment law is a huge part of prison abolition. But also, when we think about the pipeline by which people get to meaningful work, making sure that that discrimination isn't happening in education. And that's a big focus of NCLR's youth project, is we've especially recently been working very closely with the Department of Education to make sure that when they investigate claims of discrimination against LGBT students, that they're doing so in a way that makes sense, where they understand the kind of bullying that's been happening. Like, for example, one thing that often, I don't know if this is unique to LGBT students or targets of bullying, but a lot of times what happens is that student who's actually the target of bullying becomes pegged by the school as a troublemaker for either for actually fighting back, or one of the tactics of the people who are bullying or harassing them is to claim that they are the harasser, that they are the one who started it. And because of how especially transphobia against trans girls plays out in schools, and especially for trans girls of color, the school sees them, kind of pegs them already as, oh, this person is obviously the troublemaker. So that's kind of one way. Discrimination in housing, it's been very clear that if you have stable housing, you're a lot more able to hold down a job. Making sure that people who are incarcerated and getting let out have appropriate re-entry programs. One thing that we hear a lot from trans women who are getting out of prison is that their probation officers won't let them use their the name that they actually go by and have been going by probably, but won't let them use that name outside of prison. So they're once again they're either forced back into the closet in kind of the wider world, or they're sort of in the closet to their probation officer and then using another name elsewhere. Obviously, the stated justification for this is that you're not supposed to use a false name when you're on probation, but it's a little bit ridiculous to call a transgender person's name a false name when in fact that's it's just not their legally recognized name. The fact that a lot of, again, LGBT people are disproportionately represented in the undocumented population as well for a variety of reasons. And we have an immigration project as well at NCLR, and in some ways, one of the most rewarding things at NCLR is seeing our immigration clients, after after we're able to help them move from an undocumented status to getting some kind of documented status, their lives just completely change, and they're able to thrive in ways that they themselves weren't even able to imagine often before, and they're able to find education, find meaningful work, and kind of lead lives that are much bigger and fuller than they could when they were undocumented. And I know I have a very short time left, but I want to share my own personal take on this, which is when you're more able to be yourself and you feel less precarious. So I am an immigrant, and I just got my green card a year ago. And it's not like NCLR is some kind of oppressive, horrible workplace. But once I got my green card and I felt like my being in the country wasn't dependent on NCLR's ongoing retention of me as an employee, my job actually felt easier and better. To kind of have that weight lifted. And I know it's true for trans people who are able to successfully transition on the job, for example. So any way that we can help LGBT people be more fully themselves in the society is a way that we're helping them, find, maintain, and thrive in their work. So, yeah.
So my assumption is that the thing that was supposed to be a 4 is going to be more like 410. Do we think that's a plausible assumption? Then we'll run with it. So we've got, maybe 5 to 10 minutes if the panelists want to take a little bit of time to kind of interrogate each other or comment on each other's comments. That would be nice before we sort of open it out to the room.
I'll just mention that Transgender Law Center started as one of the many projects at NCLR 12 years ago. But somebody who got a fellowship after law school to start that project, and then we spun up to become our own organization. It's all very closely related here.
Yeah, I'll follow up on that point too, because I forgot to mention as part of the LGBT program at Sierra Lake started as a co-sponsored fellowship with NCLR, because once I responded to Sierra Lake's posting that they wanted to start an LGBT project, in the meeting with them I thought, well, who's the inside expert on LGBT law, because just hiring an LGBT attorney or somebody who has that area of interest, it's not like I'm a seasoned litigator, or I have some knowledge, I've taken classes, an intern, so I proposed, why don't we have another impact organization that has a very high level of expertise in LGBT law. Why don't we invite one to join us in doing this project and join us in a formal way as a co-sponsor for the fellowship, so that combining the synergy of the strengths that both organizations have can really kind of pack the right punch that we want to have an impact on the problem. So NCLR was a natural fit, because I think the organization pays particular attention to intersectional issues around race and poverty and rural issues. So yeah, it worked out very well.
With that,
I have a question for Jacob.
Okay.
Sorry. I wanted to ask you, this is a leading question because I already know the answer, but
sure.
I wanted you to talk about the work that you all are doing with Title VII on coverage for same-sex partners and spouses under healthcare plans, that
Sure.
theory that you're using.
Yes, I was just thinking that was a thing that I meant to mention in my first intro and forgot to. So another big area where my firm does work relating to LGBT people is again, around benefits issues for same-sex couples. So whether that's, for example, with a pension plan, does your partner have the right to benefits under that plan if you pass away? Or do you have the right to get your partner on your health insurance? Things along those lines. It's actually something that is interesting, because they're under ERISA, the federal statute that governs these plans generally, there are some provisions of ERISA that specifically protect spouses, typically around kind of what happens with a pension, to your pension benefits if you pass away, and protections for who you can assign your benefits to. So if you're married, you can't say, well, I want to get my pension, and then when I die, I want it to go to my neighbor Joe, without your spouse agreeing to that. There's protections written into law for spousal relationships. And so with Windsor and the downfall of DOMA, there's this sort of development in universe there around those spousal protections now are going to be applied to same-sex married couples. But even prior to Windsor, within ERISA, there's no rule that prevents. There's lots of areas where ERISA doesn't specify whether you have to provide coverage to somebody's same-sex spouse or not. That's not something that's changed. But in the Title VII world, with some of the things that Ilona's been talking about around reading the prohibition on sex discrimination to prohibit discrimination on the basis of sexual orientation, there are arguments to be made there that even though it doesn't violate ERISA, to say, provide health insurance benefits for opposite sex spouses but not same-sex spouses, you may have a Title VII problem there. And so my firm, and in the benefits context, there's a lot that depends on the particular type of plan. And so sometimes we may have ERISA claims coming alongside of Title VII claims, sometimes we may have one or the other. We've been doing a lot of work around making sure that same-sex couples are able to access the same kinds of benefits through employee benefits plans as opposite-sex couples. Another little twist there, and then I'll stop talking on this particular question, is that right now, there are easier arguments to be made when you have a same-sex couple that's married. If you have a same-sex couple that's in a civil union or domestic partnership, there's another set of arguments to be made there, particularly if they live in a state or in the case where one spouse has passed away, where during their lifetime they weren't able to be married, but they were able to have a civil union or domestic partnership. There are arguments to be made that as a matter, that you have to recognize that if that was a marriage because this discriminatory law prevented them from getting married. But that's an interesting area where it's still not clear, and it's something that we among others are pushing on that issue, but it's not a totally settled matter. So did that satisfy your leading question?
I'm just excited about that work. So
Okay, let's take some questions.
So I'm just kind of been struck hearing you all talk about the range of things that you come to the table with that you're thinking about on a day-to-day basis, from health insurance and benefits to your coworkers and your migrant coworkers throwing you into a ditch. I guess undercutting a lot of that is that class enters into a lot of this as well, and the LGBT rights movement more generally. That's always sort of an issue, is like what part of the community is being served by where we're putting our efforts. That was somewhat of a debate that comes up around marriage issues, but on some level, you can make a plausible case that everyone benefits from a right to marry. It's maybe less true of a change in how ERISA is interpreted. So it's the extent that some of this is going to become more of a focus as potentially marriage moves off the front burner. I'm just curious, to what extent do you think it's possible to be tackling some of these issues in a way that's helping everybody across class lines, or to what extent it's going to be a little bit more of a question of where are we focusing our energy and who's going to be able to benefit?
Well, I'll jump in David's defense. That I think one way that the work that your firm and us and others are doing about access to health insurance can benefit everybody is that what we're doing is creating arguments, like establishing legal arguments for equal treatment for transgender people that are then applicable across the whole range of, areas of life that may be covered by laws. So, there are, whether it's public accommodations, like when we establish precedents, say, about employment discrimination, we can then apply that to schools and public accommodations and homeless shelters, things that affect everybody, even people without jobs. And the same with the health insurance access, healthcare access. We're creating arguments that we can then apply into federal programs like Medicare or Medicaid, and now with the ACA, state insurance exchanges, and so it is something that even if the focus of the work may be on like the easiest thing to grasp, maybe for immediately benefiting people who are more privileged, it has a dramatic impact on that's much broader.
One thing I would add is that I think I get what you were saying about after marriage, the focus shifts, but I wanted to say also that I think for our organizations, the focus has never not been on these issues, and marriage has kind of come up recently as something that that NCLR has kind of taken on because it sort of unexpectedly became a big federal issue, and we felt the national LGBT legal groups felt like we had to get involved to make sure that the legal arguments being presented, were kind of, one, good enough to win, obviously, but also weren't advancing the kinds of arguments that are actually deeply conservative and in some ways anti-LGBT, even as we were arguing for what on its face is obviously an advancement for at least LGBT people, but also transgender people, because if you don't have to face questions about your gender when you're getting married, it's kind of nice. So, so I did want to add that it has always been our focus. NCLR at least, and I know TLC as well, one of the things that we believe in is that organized labor is one of workers' strongest tools to kind of shift the balance of power in the workplace in a way where workers' rights might actually matter to employers. So we have some relationships with unions, and we're always ensuring that in our events that we're using union labor. I think it's at least whenever possible, and possibly always. So, yeah.
Can you spell out some that you just alluded briefly
Yeah.
to sort of arguments that might make sense? Do you feel like in the short term, but in the long run, be sort of strategically?
Oh, sure. So,
like what can you?
yeah, I think probably the most obvious one is that kids are better off with married parents, and that has been something that. In some ways, I don't fault people for kind of jumping to this argument because it's something that the right wing has used to beat us over the head with, is that it's bad for kids to be with to be raised by same-sex parents, and I think a natural response is, well, if you think it's so bad to be raised by unmarried same-sex parents, isn't it? I mean, if you think it's so bad to be raised by same-sex parents, isn't it, better for us to be married same-sex parents than unmarried same-sex parents? But I think, part of what we wanted to get into say is to make sure that that wasn't an argument, that there is in fact no proof that kids are better off with married as opposed to unmarried parents. I think what there is proof of is that kids are better off with more adults raising them than fewer. I think that's probably what the research actually points to. What we've always focused on is the dignity, like a lot of the harms are dignitary with the denial of access to that status. So that's one kind of prominent example. And just any kind of argument that suggests that being married is somehow inherently better for a relationship than not being married, because I think that's kind of where it's very tempting to fall into those arguments as opposed to more of the ideas of fundamental rights to equal protection, obviously, and that idea of dignitary harm. So,
yeah. I guess my question is, like, given that marriage equality is becoming much more
I mean, I think that it's a difficult one in the benefits context in some sense, because particularly as the option to be married is there, I think that you can kind of make the argument of, like, in a state that doesn't have marriage equality but provides civil unions, you can make an argument to an employer of, like, listen, it's discriminatory to treat civil unions differently from, or to treat a committed same-sex couple in a state that has no legally recognized status different from, you know, an opposite-sex married couple. And there's this sort of sometimes stated, sometimes insinuated premise of, like, well, they would get married if they could, you know, because of course, why wouldn't they? And I do think that those arguments become harder when it's an option, because, you know, historically in employee benefits plans, there is a distinction made between married couples and unmarried couples. And that's something that outside of the context of same-sex couples who could not get married, there hasn't been a lot of pushback on that general premise of, you know, in general, the idea that the way we organize who has health insurance in our society is because you have, you know, an employer, and then somehow because you're employed by this employer, that your spouse then gets covered. I mean, it's sort of, there's weirdnesses to the system that are, you know, bigger than just this issue. But, you know, whether there's going to be enough momentum to, like, push back in a meaningful way once there's marriage equality on the general premise of we sort couples based on marital status, I don't know if there's actually going to be enough kind of political will and energy there to make serious ground on that. I don't. So
I'm
I don't know if
moving
you
to
guys
CLR,
have
so sort that out. I think they are. They're working on it for, you know, family.
Yeah, I was going to say that my thoughts on this are that there is a kind of fear, I know, in the family bar, and probably in the employment bar, that once we get married, a certain, like, little, it's not exactly a golden age, you know, like, that would be too strong a word, but a certain period where, because same-sex couples didn't have access to marriage, what we were pushing for, the only thing we felt was politically possible to push for, was something like marriage, but that would be open to people who weren't in romantic relationships as well. But at the same time, I think at NCLR, we've always felt that actually that is a better policy than tying things to marriage. In the family law context, it's to not tie parentage to marriage, for example, but rather to the actual relationship that kids have with adults in their lives. And then I think in the employment context, it might be like, do you have maybe financial interdependence, or something that makes sense for why is it that you need to share benefits with this person? Or, of course, if we had universal health care, you know, that but I think maybe what we'll have to do as LGBT people is to continue to work in coalition with other people who are advancing kind of these arguments and policy changes. I mean, I think, for example, like, part of why we had this little mini golden age is that there are a lot of unmarried straight people who wanted benefits for their girlfriends, boyfriends, partners, whatever. And they also, or people living together in relationships of care, raising children together who aren't couples. This is in the family context again, sorry. And those people kind of saw that, or LGBT people saw that we could work together to get the things that we all needed, recognition under the law. And I think we're just going to have to continue to do that. It may be a little harder now that there's this very public marriage thing, and I think there is going to be a lot of pressure on at least gay, lesbian, and bisexual people to fit into a certain patriarchal, capitalist model of the family, and how you're supposed to protect your loved ones is to get married. But I think we can still continue to resist that and find other people who've decided to resist that as well.
So I've just received word that First Person is starting, so I want to give people the opportunity to go to that. It's in room 180. But all of our panels are fantastic and really would love to speak with students and undergraduate youth in this room. We'd love to speak with them.
And we would also love to have you all apply for internships and summer, either during summer or the school year with us.